The February 21st preliminary inquiry in the case of William Danny Mason, Ashton Vanegas of Kamalute Village, and brothers Kieran Fernandez and Terence Fernandez, as well as Ernest Henry Castillo, all of Roaring Creek Village, is expected to be drama-free. They will be committed for trial on charges of murder, kidnapping, conspiracy to commit murder, and conspiracy to commit kidnapping in relation to the attack on David Dodd and the brutal beheading of Pastor Llewellyn Lucas. But this morning, there was one last twist on the road to that date: the decision by Director of Public Prosecutions Cheryl Lynn Vidal to drop the charge of conspiracy to commit kidnapping against Mason's wife, Melissa Ferguson, for insufficient evidence. Of course, the Canadian national and her attorney, Richard Dickey Bradley, had always maintained her innocence, and now they want an apology and their pound of flesh from the police department.
There was no evidence that I was ever involved in anything in the first place.
Do you feel relieved? What are your thoughts at this time?
Yes, definitely, I'm relieved.
God be praised, she's a free woman now. She can move forward and hopefully get on with her life. And I will advise her that if she wants to sue, it is her prerogative and it is her right to do so. And that is a different matter altogether. But I know how happy she is that even without going to trial, she's exonerated 100%.
So you're saying that no explanation was given to your client as to why the charges would be withdrawn?
Not only no explanation, but the common decency calls for a little apology. Your Honor, we regret that charges were brought against her. I want to public. They can send her a letter, they can do about it, they could text it. We're dealing with a human being, we're dealing with a stranger who has lived among us. She was accused of a very, very serious matter.
On the prosecution side, Attorney and Assistant Commissioner of Police Chester Williams conceded that the DPP did the right thing. But don't expect a visit to Intelco Hill from the cops to apologize anytime soon.
The DPP, having gone through the file, decided that there was not sufficient evidence to proceed against Ms. Melissa Ferguson, and she directed that the matter against her be withdrawn.
Sir, the attorney has said that this should have been the mature decision that the police should have taken from the get-go. How do you respond?
Well, the attorney have a job to do, and he's the attorney representing his client, and it isn't wrong for him to say that. If I was the attorney for the defense, I would say the same too. But the police do act on evidence, but evidence of charge and evidence to convict is two different things. And I'm sure that when the police did institute the charges against her, they had sufficient to charge her then. The DPP who will be prosecuting the matter at the Supreme Court level decide that there was not sufficient against her and directed the charges to be withdrawn against her, which is the right thing to do in that case. I don't see the need for that, but again, he is her attorney, so he has a right to say that.
Now, do you foresee that a suit can be filed against the police for that? He has talked about that already.
Anybody can bring a suit against the police. I don't know what the suit will be for, but if it is for malicious prosecution, the law of malicious prosecution clearly states that not just because the charges are withdrawn against you by the DPP or by the court means that there is grounds for malicious prosecution. So I am sure that the attorney will be very careful when he treads if he decides to take a suit against the department where that is concerned.
The prosecution is awaiting the result of DNA testing from Miami and has marshaled nearly all of its other evidence against Mason, Vanegas, the Fernandezes, and Castillo. But will it be enough? For Bradley and Williams, at least at the preliminary stage, it is. But the Supreme Court will be an entirely different matter.
I informed the Chief Magistrate that we will not be wasting time, that the law provides that once there is some evidence, they use these Latin phrases, prima facie and so on, once there is some evidence in the file, it's not a trial, the procedure is that if there is some evidence in a file against an accused, the attorneys can make submissions or they can save that until when the trial gets underway. Trial is the proper place for that matter.
I am not the person who will decide the outcome of this case. So I'm not in a position to answer that question, but I can tell you that as an attorney and as a person who is dealing with the matter at the magistrate court level, that there is sufficient evidence in the file against the other defendants. And that is the reason why the DPP did not directed that charges be withdrawn against anybody else other than Melissa Ferguson.
Aaron Humes reporting for News 5.